Hi, everyone. I'm Carolyn Bregman. I'm one of the several members of the coordinating committee of the Emory 60 Plus Atlanta Network, a wonderful group of volunteers who get together to plan activities for you all, survey what you want to see, and will be continuing to bring you programs hopefully well into the future. If you want to volunteer with our committee, please send an email to Kevin Kell at kevin.david.kell, K-E-L-L, at emory.edu. We would love to have you. Please keep yourself muted except when we get to our 2 question times. At that point, if your question is being asked, because I'll be watching the chat for your questions, then you can unmute yourself so you and Stephanie can talk about that. And then we'll have more time for questions at the end. I want to let you know that on March 3, Gary Hawk will be presenting on the history of the Carlos Museum. And on March 24, Elizabeth Horner, who is the Ingram Head of Education at the Carlos Museum, will be presenting on the Wondrous Worlds Tour, Art and Islam Through Time and Place. So we hope you will join us for that. And you'll be seeing that in your every 2-week email that you get from our group. Again, put your questions in the chat. I'll be watching them. We'll do our best to get to all the questions. It just depends on the volume. We have given the 3 questions we got in advance to our speaker. They're incorporated into her presentation. So Stephanie, let me introduce you. Stephanie Frostbaum, Director of Gift Planning for Emory University, is an Emory Law School graduate, and she joined Emory's Office of Gift Planning in 2005. Coming to Emory from Wachovia Wealth Management, where she was a vice president and estate and wealth strategist. Stephanie practiced law as a tax and estate planning attorney for 10 years in New York, Connecticut, and Atlanta. She's a member of the state bars of New York, Connecticut, and Georgia. She has been on the board of the Georgia Planned Giving Council since 2007 and has served as its president. At Emory, where she works closely with donors who support the health sciences and law school, Stephanie's strategic focus is on increasing the quality and quantity of planned and blended gifts. Stephanie lectures often on estate and gift planning, as well as on philanthropic strategies. A native of New York City, Stephanie received her BA from Boston University. Her husband, Lane, and their children, Cameron and Sophie, are all proud Emory alumni. Stephanie, thank you so much for doing this program for us today.
It is absolutely my pleasure. Thank you so much. I'm going to share my screen now. So let's see. And I believe, let me just practice. No, I don't think I have it. Yep, here we go. All right. All right, let me just go back 1 second. I am not a technological whiz. I'm so glad all of you are here with us today. Thank you for joining us. This is a little bit about what we're going to cover. And as you can see, we're going to take those breaks to answer your questions. I want to share the human side of estate planning and help you prepare to have conversations with your attorneys and your financial advisors and your families and those who you're going to ask to play a role in your plan. We'll certainly discuss some of the technical aspects, but your attorneys and tax advisors will work through that with you when the time comes. Let's talk about planning for yourself, your healthcare, end of life, finances, and then planning for others. There's no way to give a complete planning of estate plan of estate planning, and I wanted to stay away from some of the more complex techniques. But if you have questions that I don't answer today, please give me a call. My contact information is going to be at the end. So we'll start with planning for yourself. So during my time here at Emory, I've been so fortunate to have the opportunity to work with Dr. Tammy Quest, who's the director of our Palliative Care Center. Dr. Quest has taught me a great deal about the impact that our life decisions make end of life decisions make, and even more important, what happens when we choose not to make those decisions and let them be known. The next few slides provide some important information for us to consider as we put together our own plans. So current trends in end of life care. As you could, probably know, long-term care and caring for people with Alzheimer's disease are going to be some of the most expensive things that there are. But you probably don't know that 61% of elderly cancer patients are hospitalized within the last month of life, and 20% of patients with solid tumors receive chemotherapy within 2 weeks of dying. So the National Institute of Aging shares that 25% of people on Medicare spent more than their total assets on healthcare in the last 5 years of their life, and 43% of them spent more than their total assets, excluding the value of their home. So we need to be proactive. And these are some of the things that we can do. We can create these plans. We can enact these plans. We can execute them. And then we can sit down and have honest, open conversations with our families, our financial advisors, and those who hold our powers of attorney, both financial and for healthcare. Talk to our healthcare, our caregivers. It's going to lead to an improved quality of life. It's going to lead to more hospice use and fewer hospitalizations, less deaths within hospitals, and less aggressive care at the end of our lives. So as we consider our choices, we must think about the impact our decisions have on those we love. The impact of our health on our caregivers can be devastating. Let's make sure that we give them the best tools to be successful. So many of you are caregivers presently for loved ones, and you know that even with good planning, it is a very, very challenging role. So let's talk about advanced directives and powers of attorney. So they're available to help you plan ahead and let others know what kind of assistance and care you want during your life. They're used to guide your loved ones, your healthcare teams, your attorneys and financial advisors in making clear decisions about your finances and healthcare if you can't make them for yourselves. So you need to make these decisions. You need to give them careful consideration, and you need to communicate them. So in Georgia, we have, this is what the advanced directive for healthcare is. It permits you to appoint an agent to communicate with healthcare providers and make decisions for you when you cannot. It memorializes your end-of-life treatment preferences, both providing and withholding care in specific circumstances. They're great documents. And years ago, we combined the old living will and healthcare power of attorney into a simple, very plainly worded document. And if you've not already executed one, please do. Choose an agent that you are confident can carry out your wishes, then sit down and have that conversation. I hope all of you live long, die peacefully in your own beds. But if you are in an accident and you are incapacitated, even temporarily, your agent needs to know what care you want, and they need to have that health care directive in their hands when they go to the hospital. You need to decide, do you want long, life-prolonging trips to the hospital, or is hospice care to make you comfortable, or in your home or in a hospice care facility? Is that the right thing for you? So last summer, when my kids were home and we had these conversations with them, we discussed, we had these, we talked about it. We talked about different scenarios. I think I'm supposed to go to the next slide. Let's see. Nope, sorry. We had these conversations with Sophie and Cameron, and they asked their questions, and we made it clear. And we feel good about that, and we'll continue to have these conversations. It's critical. Also, while they were home, they executed their wills, their powers of attorney, and shared with us how they want to be treated. So, sometimes the shoemaker's kids do have shoes. So our financial powers of attorney, like the healthcare directives, provide your agent with the authorization to act on your behalf. There are two kinds. Well, there are many kinds, but a limited power of attorney ends at incapacity. So if you're going on a long vacation and you want to give your brother-in-law, who's your business partner, power to run the business, I advise a limited power of attorney, but have this durable power of attorney in place because it survives incapacity, and we do not know what the future holds. If you don't have a power of attorney in place and you do become incapacitated, then what you need to do is go to the probate court. You need to have a conservator appointed to manage your property for you, and a guardian to make decisions for your health care. It's not quick, it's not easy. Our probate courts here are wonderful, but it's so much better to plan ahead, have these conversations, and have it in place. I know several of you are caretakers for incapacitated adult children, spouses, or parents. Later, we're going to briefly discuss a supplemental needs or special needs trust for those who are on Medicare. But if you are in that situation, I strongly recommend you speak with an attorney who specializes in that area of practice. And if you need, I'd be happy to make some recommendations for you. So these are some of the sample powers that a financial agent would manage. The document is very, very flexible. It is very customizable. So you go through, you'll go through the form and you'll say, yes, yes, no, yes. You choose what it is that you want your agent to be able to do for you. The right person. It is so important to choose the right person. And you can also, you can name successors. It's very important. You might want to name your spouse. You may want to name your sister. But if they are not available, if they are not able to act, you want to have a series of people named. So have your successor agents named. So, okay, I moved very quickly. I apologize, it's the New Yorker in me, but let's take a break and let's hear your questions so far.
So you can go ahead and put your questions into the chat. I'm trying my best to scan. If you want to raise your hand, I think that if you raise your hand, I'll be looking for you and can call on you. Okay, Steve, you want to unmute yourself? Okay, you are.
Is the healthcare agent usually a medical person, or can it be a family member?
No, it can be, certainly. But for example, my healthcare agent is my husband. If my husband can't act, I have my children named to act in tandem.
Okay, thank you.
Of course.
Anyone else? Some of you, if your camera is off and you have a question, okay, here's a question from Kathy. Should the directives be in writing, or is a verbal directive okay?
So if someone who is not your legal spouse marches in the hospital and says, Tom told me that this is how he'd like to be treated, or more importantly, Tom told me he would like treatment withdrawn, and you do not have the legal documents, then the doctor is not going to be able to listen to you. They may be able to, they would certainly take into account treatment that, you know, you may suggest, but no, you need to have the documents. You can download them from the internet. You can, let's see. Yeah, I mean, if you Google them, they are out there,
Okay.
and you know there are official forms. But if you are meeting with an attorney to work on your estate plan, it's a good idea to go over that with them.
Okay, that's great. Thanks.
We have a question from Marty Rotter. Marty?
You may have just answered this. Do you think the state forms for advanced directives are adequate?
They are. You know, they are adequate, but you will read it and you'll give it some thought. And especially, you know, the healthcare document, it is what it is, and it gives you the options. If I am in an irrevocable coma, if I am in a terminal condition that has reached this certain point, I want you to do everything in your power to make me better. Or I want you to withdraw treatment, but let me still have nutrition and hydration, or withdraw everything. You'll read through it and you'll see. I mean, it is a great document.
Stephanie, we've had a question. I know you're going to be getting to this. We've had a question from Martin to please discuss the role of trusts and when they should be set up. And we had a question in advance about trusts, and Stephanie will be talking about that. We have a couple of folks with their hand raised. Let's see if I can, if you don't mind physically raising your hand. Let's see.
Looks like John Stallman has the little, oh, there he is, has the
Okay,
little.
John, and Marty has another question, I believe. Let's go with John.
Hey, thanks, Stephanie. Just a quick question. I kind of know the answer to this, but generally if you have some power of attorneys created or healthcare directives created not inside Georgia, will they still be recognized? If it, you know, obviously something happens in Georgia?
You know, if it has the right information, if, you know, if it is executed in, you know, with the same number of witnesses or powers of attorney that the Georgia form requires, then yes. But it's really, really easy to download the form, or, you know, again, when you're working with your attorney to get them done. And you'll see at the end of the form the required number of witnesses, the notary for the financial powers. So, you know, if you live in Georgia, get the Georgia forms. Come to my backyard, I'll witness it for you.
Thank you.
Marty, you have a question? Marty?
No.
Robb? Okay.
No.
We did get a question in the chat, wondering if you'll be mentioning online resources to use, since someone on the program does not live in Georgia and would be looking for different options.
So, you know, I don't have at my fingertips resources for out of state. I am going to put up the website for my office, the office of Emory's Office of Gift Planning, where you can download some amazing brochures. But email me and I'll see, you know, you'll tell me where you live, and I'll see if I can help you with that.
And Stephanie's email address will be available at the end of the program.
Or stephanie.frostbaum@emory.edu.
Nice and easy. All right, Stephanie, ready for next part?
Next slide. Okay, we're going to talk about planning for others. So it's time to talk about actual estate planning. One of you had emailed me earlier and asked, do I really need a will? So, you know, my answer is definitely yes, but it's not all that you need. So let's do a few slides on why you need a will. Without a valid in-force will, you're not going to exert the control that you have the opportunity to. You're not going to, the state is going to tell you exactly how your estate will be divided. You won't be able to create a structure that is going to minimize conflicts within your family and provide for a smooth transition of your assets. Without a valid in-force will, your estate will be in intestacy. The state then steps in and controls many of the decisions you may prefer to make yourself. For
I'm sorry, are you
example,
showing slides? Are you showing slides?
yes, I am. Can
No, I
you,
don't see them on my screen, sorry.
Carolyn, do you?
No, that may just be, I think that was Mr. Richards, and that may just be your screen. Unfortunately, I won't be able to troubleshoot that for you.
I'm sorry, I found it, thanks.
Oh, I'm so glad, but we can email this, to anyone that needs it later on. So we're talking about intestacy and that the state provides the plan if you choose not to have one. So for example, if you have a surviving spouse and 2 children without a will, the state is going to direct that 1/3 of your estate goes to your spouse and 1/3 to each of your children. If you have more children, the state's going to make sure that your spouse gets at least 1/3, the remainder being divided between your children. It's not all of your property. We're going to discuss, probate property in a little while, but let me ask you, for those of you who are married, does your spouse want only 1/3 of your estate? I mean, right now they're used to, sharing all of it with you. So that is just something to keep in mind. If you have no spouse, each child is going to receive an equal share. But growing up in my family, fair did not mean equal. My parents have 3 children, and each of us have always had different needs and different abilities. Fair in my family did not and does not mean 1/3 for each of us. I'm sure for a lot of you, that situation applies too. So the other thing is that assets are going to be distributed at the time that your will is administered. And so you don't get to take advantage of so many of the wonderful benefits that trusts can provide for your children. And we'll talk about that later. And what about the family member who is going to inherit that has no ability to take care of money, or who does not have the capacity to take care of money? So we'll talk about all of that in a little bit, but another reason to have a will. So let's talk about personal property and the role that plays in a will. Who do you want to receive your great-grandma's wedding band? Or, what about that painting hanging in your living room that your best friend loves? If you want to distribute your personal property, you need to either put that in your will, or your will can have a provision that says, to distribute my personal property, I've created this other document and my executor has a copy of that. I think that's really important. Philanthropic planning. So many of you make gifts every year to your college, to your church, to the Humane Society. Is this the time to cut them out of your legacy? Have a will, leave your philanthropic gifts. Oh, let's talk about blended families. So this is really, really important. The laws of intestacy will leave nothing to your stepchildren. You have loved them, you have raised them since childhood. Intestacy says nothing. Or those grandchildren that by blood only belong to your spouse. Intestacy, 0 for the grandchildren. Have a will. So today we define family differently than we may have in prior generations. And they're not necessarily those who are just related to us by blood. Please consider this when you're deciding whether to invest in getting a will. Let's talk for a minute about fiduciaries. Okay, so under your will, you will have an executor. You will probably have trustees. The executor is going to be the person or the company whom you appoint in your will to distribute your estate at your death. If you have no will, then it's going to be called an administration, and the administrator will be appointed by the probate court. So their basic responsibilities are going to be to identify your assets and your liabilities, to make an inventory, to probate the will, to pay all of your debts and taxes, and distribute the property to your beneficiaries, including distributing assets to trusts as you've directed in your will or your trusts. Now, the trustee is the person or company responsible for managing the property or assets placed in your trust with a legal obligation to administer it solely for the purposes you have laid out in the trust. I'm gonna get some water. This is lots of talking. So who you choose to be your executor and your trustee does matter. If you choose your spouse or your child because you love them and you trust them the most, you should also consider whether they are capable of fulfilling these responsibilities. But fear not, you can name co-trustees and you can name co-executors. So you can certainly name your spouse, your aunt, along with your the person that you really do trust to fulfill these responsibilities with great care and skill. So one executor would be there to know the things that were important to you, and another to really do the job well. And there are certain situations where a professional or corporate trustee or executor would be absolutely appropriate. They can act dispassionately and unemotionally in very difficult situations. And this may be a very good idea when we discuss special needs trusts and spendthrift trusts. So let's move on to the wills. The will is going to control some of the flow of your personal property, but the will is not going to control what passes by contract or beneficiary designation. So it is not going to it's not going to control your life insurance. You know, you have a beneficiary of the policy. It won't control your retirement plans unless, of course, you put it into a very special complex trust. Any accounts you have payable on death, that the house owned in joint tenancy with the right of survivorship, and those trust assets. So these are non-probate assets. They will not pass through your will. So when should you review or revise your will? Oh, often, regularly. Anytime there is a big change in your life, if you get married, if you get divorced, if you adopt or have a child, you open or sell a business, there are big changes in your financial situation. As you're planning for retirement, this is part of the plan. You need to review and revise your will as necessary. And during this pandemic is actually a great time for you to work with your attorney to create that first will, because I know a lot of you out there do not have wills, or to revise a will that hasn't been looked at in a long time. We're spending so much time at home now, and we're really giving a lot of thought to the things that are important to us. At work at Emory, I am working harder and accomplishing more than I have in the prior 15 years that I've been there. You know, so many of my donors are reviewing their estate plans and saying, you know what, it is time that I put Emory in my estate plans, either beneficiary of my retirement fund or in the will. I mean, this is a great time to be doing that philanthropic planning as well. My husband, Lane, who I met in law school when we were both at Emory, he, as an attorney, has been very, very busy with his clients who are doing estate planning. And very often on the weekend, we have them coming to our backyard to execute their wills and trusts and powers of attorney because they require witnesses and notaries. So it's important that we, during this pandemic, can accommodate people and do our planning in safe spaces. My backyard is perfect. Love doing it there. So let's keep going. Testamentary trusts. So testamentary trusts are going to be those trusts that are created under our will or created at death by a trust that's triggered, a trust that is ready to be funded at your death, excuse me. So marital trusts are often used in order to take advantage of the tax marital deduction and still control the ultimate distribution of assets at the death of your surviving spouse. So a marital trust can also provide asset management for your spouse if they're unable to do that for themselves. It is also a great tool for planning for a spouse who may not be the mother of your children or father of your children. We were talking before about blended families. The Q-tip trust is a great tool to make sure your wife has or your husband has what they need during their lives, and then at the end of their lives, that the trust that the assets pass out of the marital trust and either outright to other beneficiaries or into, let's say, a family trust. The marital trust is also, as we said, a great tool for preserving that unlimited marital deduction in your wills. Let's talk for a minute about these family trusts. So I have the best kids. I mean, truly, they are amazing. They bring me such joy. They are responsible. They are attentive. But under my will, I have trusts set up to protect them from the hazards that life presents. When I die, money is going to pass into a trust for them. It is going to protect them from bankruptcy, from creditors, from a future ex-spouse, from their own poor judgment, or if they become ill physically or mentally, their assets will be in a trust, and that trust can pay for their health, their education, their welfare. The trustee will have discretion to take out a larger chunk of money for them to start a business after the trustee has reviewed the business plan and says, you know what, this is a good idea. It will pay, I said, for their education. It can pay, they can take money out to pay for a wedding if I'm not there to do it for them. Another thing is, we make the decisions on how money is distributed from this trust. It's taking care of them while the money's in the trust, but perhaps they will get a third of the corpus at 40, a third of the corpus at 50, a third of the corpus at 60. Yes, I believe in older ages because they can get the money they need, but as long as the money is in that trust, their inheritance is being protected for them. The revocable living trust. So you probably all heard of living trusts, revocable trusts. If you live in Florida, if you live in California, if you live in New York, where probate is really difficult, really expensive, really challenging, your attorneys will probably recommend some form of the revocable or living trust because it's really going to help avoid those complicated probates. It's also going to provide asset management for all of the assets that are in that trust. The trustee, who can be you, can manage all of the assets in the trust. And if you become incapacitated, there can be a smooth transition from your management to the successor trustee to take care of the assets for you. It can avoid guardianship. It also can act as a will substitute and distribute your assets at your death. It can provide succession of management, as we just talked. It is flexible. It is really good at protecting vulnerable beneficiaries, the minors, the spendthrifts, our heirs who are lacking capacity. You can provide your charitable gifts within the living trust. And you can do your estate tax planning within the revocable trust. But what it does not do, it does not provide you any asset protection. It will not protect against the costs of end-of-life care. It does not impact your income taxes, and it does not manage assets that have not been titled in the trust. So if you have a huge brokerage account, but you have not titled it in the name of the trust, if my brokerage account is not titled into the Stephanie Frostbaum revocable trust, the trust can't manage it. So what we, and as you're creating it, your attorney's going to advise you on this. Listen to them. So what we do in conjunction with the living trust is we have a simple pour over will. This simple will is going to have provisions such as your personal property, your great-grandmother's ring to your favorite nephew, and any assets that you have not moved into that living trust. The pour over will is going to say, any assets that this will controls that I have not titled in my trust, I hereby leave to my living trust. So this simple pour over will be probated, but the living trust is not. The will is a public document. Once it is probated, your living trust will never be made public. So if you are leaving assets to someone that it is none of anyone else's business, you can keep it private within the living trust. Beneficiary designations. Remember before we were talking about those assets that are not probate assets. We use beneficiary designations for your life insurance, for your retirement fund, and that says who gets it when you pass away. Review this. Review your beneficiary designations as your life changes. A lot of people who get divorced forget to change the beneficiary from their ex-spouse on their life insurance, on their retirement funds. Please make sure that you do it. Oh, and by the way, a retirement plan is a great asset to use for charitable planning. It is the most highly taxable asset that you have because you have not paid income tax as you're putting the money in there. As money comes out, it is taxed at your highest tax bracket. So every dollar you give from your retirement fund to a nonprofit is $1 in their pocket. $1 from your retirement fund to a child could leave 50% of it, maybe even less. Excuse me. Life insurance, if you want to take it out of your probate estate, if you have a very large taxable estate, then irrevocable life insurance trusts work great with life insurance. Let's talk about disclaimer trusts. This is a great trust. So it allows a beneficiary under your will to disclaim, to say no thank you to assets that are left to them under your will. So this allows the surviving spouse who has been left a tremendous amount to say, you know what, I don't need all of this, or the tax plan that we put in place many years ago is different now. So instead of keeping all of this, I'm going to take part of my inheritance and put it, I'm going to disclaim it, and I'm going to send it down into this disclaimer trust. so that it moves down to your other beneficiaries. It is a great tool, especially in these uncertain times where our tax laws may change greatly. It allows you flexibility and to do some post-mortem tax planning. Spendthrift trusts. This is a great tool. So it's commonly used with family members who are unable to handle their own money and are likely to squander an inheritance. It is often used for addicts. In planning the trust, you decide if you want to set payments for a beneficiary every month or quarterly, or to have the trustee have total discretion over when and how much to give, or to turn off the faucet. So let's say you have set up a spendthrift trust for someone who is drug addicted. You can direct that your trustee is going to pay their rent, pay their bills, give them a small allowance, but they will have discretion to say, you know what? I'm going to require that you show up monthly for a drug test. And if it is positive, the faucet gets turned off. You know, you can still pay their rent, pay their bills, but you do not put money into their hands. This is, it can help with a very difficult situation. We all have people in our lives with questionable judgment, and the Spendthrift Trust is a really, really good tool for that. Supplemental needs or special needs trust. I know that one of you had sent an email asking about this. So this is a trust that is established for someone with special needs that typically have lifelong mental or medical disabilities. This trust provides for an individual without interfering with any government assistance that the individual may be receiving. So this is a legal trust that is governed by the rules of the Social Security Administration. The beneficiary can have no control over the trust, over its administration, over its very existence, or the distribution of the assets. Because a special needs trust is so very restricted, it is easy for this trust to fail to meet its goals by improper administration. So you have to choose the trustee very carefully, and you may want to consider a corporate or a professional trustee. This trust is not going to take care of people's everyday needs. They are receiving Medicare, but it's going to provide for the extras above what the government is providing. And again, if this is something that you have more interest in, I am happy to talk to you. I am not the expert, but I would be happy to recommend someone who is. A question break.
More time for questions. So
Yeah.
you can put them in the chat. I'm scanning to see if you have your hand raised physically or virtually. Let's see if we have questions here. Okay, still scanning just in case. And if not, we'll be able to move on. All right, Stephanie, I think you can go forth.
All right, one more sip. Tea with honey. In an Emory mug, of course. All right, let's dig into those taxes. And we're going to gently explore what the future may hold. So let's talk about the federal estate tax exemption. When I started practicing law, it was $600,000. So the amount that a person can transfer at death without being subject to the estate tax was $600,000. Fast forward, it is 2021, and individuals' federal estate tax exemption is $11,700,000. For a married couple, the exemption combined is $23,400,000. May you be blessed with a taxable estate. There is plenty you can do to do planning. Okay, so this current law sunsets in 2026 and will drop to $5 million. So that means if a new law is not enacted, then in 2026, the federal estate tax exemption automatically drops to $5 million. If you are not familiar with a step up in basis, I thought it's something that we could talk about a little bit. So we each buy assets. The price we buy it for is our basis. If you inherit property from someone's estate, your basis in that property is not going to be what the decedent initially paid for that asset. It is going to be stepped up to the fair market value as of the date of death. And this applies to all inherited assets, including stocks, bonds, and real estate. So my grandfather bought AT&T many, many years ago, let's say for $1 a share. He passes away. I inherit 50 shares of AT&T stock. It is no longer selling for $1 a stock. It is selling for $100 a share. Fortunately, I get a step up in basis. So my basis in the property is now the date of death value, that $100 a share. So if I choose to sell that stock, I don't have to pay capital gains on the difference between the $1 he bought it for and the $100 it is valued at now. My basis is $100 and all of those capital gains are wiped out. Yay! Gifts. I know we all love receiving gifts. The annual gift tax exclusion is now $15,000. So this is the amount of money that you can give as a gift to any one person in any given year without having to pay a gift tax. You can also, this is very nice, give up to 5 years of annual exclusion to create a 529 account, which is a specific type of college savings account without using any estate tax exemption and still stay under the gift tax exclusion. So taking advantage of this rule, a single person could fund a college education account with $75,000 on behalf of a child or grandchild or someone they really, really like without having to utilize the exemption. And a married couple could fund the account with $150,000. That is a really nice gift, and it is not taxable. You can also make payments directly to a university to pay someone's tuition. You can pay directly to the provider someone's medical bills, and those also are excluded from the gift taxes. So on very large taxable estates, a lot of professional advisors advise high net worth clients to make large taxable gifts to utilize their exemption amount. However, there's a real possibility that the Biden administration is going to seek to reduce that exemption amount. So we're currently in a situation where you could use your exemption right now by making these large gifts, or wait and make gifts at death. But I strongly recommend that you never give anything away that you may need. So that is very important. When I am talking to my donors about making large gifts, I am always so greatly appreciative when they want to create an endowed fund. I always make sure that this is not an asset that they need before they give it away. It is very important. Take care of yourself first before you risk making large gifts to a charity or to someone you love, please. So, the future of the estate tax. This is speculation. I've been reading articles. I'm sure many of you have. You know, the Biden administration, made a lot of statements during the campaign. They say that they were going to lower the federal estate tax exemption, do away with that step up in basis, reduce gift tax exemptions, and possibly make these changes retroactive, or they may not. And, we just don't know. But be aware as you are planning, as you are talking to each other, as you are having conversations with the ones you love, your professional advisors. We have a set of rules now. They may change. So revisit your plans and, keep thinking about it. So someone had asked about brochures. This is the website for the Emory Office of Gift Planning, where I blissfully, well, I don't really work there physically. I work here in my house, but our website has some great brochures. Here's a list of a few of them, what to do in the first 48 hours after you lose a loved one. I find this very helpful, and I refer to it: estate planning starters, navigating estate planning for blended families. We have a lot of different brochures on this website. There is a lot of information, not just on philanthropic planning, but generally on estate planning. So my last slide here is my contact information. I would be happy to answer any more questions, refer you to someone. Feel free to call me or to email me. And we have some more time. So if you have some more questions, I am here.
Thank you, Stephanie. That was a fantastic presentation.
Oh, my pleasure.
We did get a question in the chat. If you give less than, right now, if you give less than 15,000 to a child in 2021, do you have to report it on your 2021 income tax forms? How does it work?
No, they're the freebies. And, and I don't know if I mentioned this, but you can give that 15,000 to as many people as you would like, if you can. But again, take care of yourself.
Okay, if you want to raise your hand in the audience, if you have a question.
Or you can type into the
Or
chat
type
if you know how to
into the
do
chat.
that.
All right. Let me just double check. We've had a few things come into the chat. Oh, here's a question. We've gotten some thanks for you, Stephanie. And I will be paying medical caregiver costs for my mother next year. What do I need to fill out to not pay taxes on it? It will be much more than 15,000.
So I am not perfectly sure if paying a salary, if paying for a caregiver for an aide is exempt. Certainly all of her medical bills, pay them directly to the provider. But as far as if we're talking about salary for an aide, I'm not quite sure. But if you email me, I'd be happy to look into whether you can pay that on her behalf with no tax implications.
Another question, Stephanie.
My favorite story about that is when my son, who's my first child, was being born, my grandfather was still alive, and he insisted on paying all of my medical bills to have my son. That was just beautiful.
There was another question on the gift, on gifts. If I give more than 15,000, what do I have to do then as far as my income tax forms?
You know, technically you file a gift tax form, check with your accountant. I haven't done one in a really long time, but technically, you know, you file a gift tax form. You're not going to be paying taxes. You know, if you give $100,000, that 85,000 above the 15,000, that just goes toward that $11.7 million credit that you have to use at death or in life. So you're not paying taxes, but check with your accountant. You may have to file a gift tax return.
Okay. So together with that, this is Doris. I'm the one who asked the question.
Hi, Doris.
Hi. So if you're an executor of an estate, the trustee is in agreement, and you make a large gift from the estate to an individual, but it was not, specified in the will. Can the estate then be the one who made the gift, or is it going to be the person who primarily inherited from that estate, who may or may not have been the executor? Would it be their monkey then? Would it be?
Okay, so let me see if I understand, Doris. The executor does not have discretion to make gifts from your estate if it is not in your will. Your executor must foremost follow the instructions in the will.
Okay.
So
So
your executor does not have that discretion. If the will creates a trust and the trustee has discretion to make distributions to that individual, then the trustee can do it. But if it's not in the will, the executor can't do it.
okay. Let's see. Okay, I think that helps. Now, if right now it's 11.7 million, and if Biden or whomever changes it down to 5 million, and let's say, a couple $100,000 have already been gifted, that goes towards the lifetime maximum, right?
Yes.
And the new maximum, if they reduce it, it wouldn't be against the 11.7 anymore. It's whatever the maximum is at the time of death. Is that right?
Yes.
Gotcha. Thank you.
All right, we've got some more questions, Stephanie. Sorry, we've got some more questions that have come in. Are there other sites for learning about the different kinds of trusts? And also someone asked about the if they can go to the website for your office for the brochures and other information, and what is that website?
So the website is, excuse me. I cleaned off my desk for all of you. And so so our website is emory.edu/gift planning, one word, emory.edu/gift planning. So we have great information there. A lot of major universities, their gift planning office has great information. There is tremendous information out on the web on different trust types. I mean, I just Google things all the time. A lot of the big brokerage houses, fantastic information.
Stephanie, we've had a question whether you need to use a lawyer to set up a trust.
So, there are websites out there. where you can buy a kit and do it yourself, I don't advise it. You know, if you have the simplest plan, I'm leaving everything to Norma, you know, sure, you can use the will kits. But, you know, one thing that's really important, and I'm sorry I didn't mention this, you know, another thing that the will does is it gives powers to the executor, such as you do not have to file that inventory with the court and make all of my assets public. You do not have to post a bond with the court and spend my money that way. When you are intestate, when you don't have a will, your administrator will post a bond and they will file an inventory of all your assets.
Stephanie, a couple of other questions. We've had a question on 529s. Andrew asked, could I put 75,000 into a 529 for my daughter this year using the step up with no federal tax due on the capital gain? She is now over 25.
Okay, two different things. Yes. So you can put the 75,000 in, you're using 5 years worth of that annual gift. Read me the step up question again.
Sure. It says, could I put 75,000 into a 529 for my daughter this year using the step up with no federal tax due on the capital gain? She is now over 25.
So I'm assuming you inherited some stock and so you have the step up in basis on that stock. I don't know that you can fund the 529 with that stock. You may have to liquidate it and then use cash to fund the 529. I'm not sure, but in any case, if the fair market value of the stock is equal to your stepped up basis, when you sell that stock, you will not be incurring capital gains if it's a wash. If your inherited basis is $100 and the fair market value is $100 when you sell it, no capital gains. If your basis is $100 and you sell it at $150, then you're paying capital gains on 50.
Andrew has added in the chat that this would be for graduate school and also that it's long held stock. If he has to liquidate, then would that trigger a capital gain?
Yes. If you have low basis stock and you sell it, you incur the capital gains.
Cindy notes that there's been a Georgia law change on inventory and reports, that things must be specifically referenced, not enough to refer to the broad powers in the code.
Thank you.
I'm looking to see if I've missed any questions, but I think we've caught everything. And let's see if we have anyone else raising a hand. While I look, Stephanie, let me thank you, and let's all give Stephanie a virtual round of applause for a fantastic program.
Thank you all so much. I really enjoyed being with you tonight.
Thank you. The program has been recorded. We will be sharing it out once we get that recording. So please stay tuned for that. And I'm looking to see, I'm not seeing other things right now. Andrew did follow up with, could I gift the stock at 15,000 per year?
You absolutely could, but your sweet daughter will then, in order to pay tuition, will have to sell it and she'll pay the taxes. But you know what you can do? You can make a charitable gift with your low basis stock, completely wipe out that capital gains.
All right, folks, thank you all so much, Stephanie. Remember, please join the Emory 60 Plus network on our Facebook group. If you're on Facebook, we do send out emails pretty much every 2 weeks on Friday afternoon, so keep your eyes peeled for those. We'll be announcing our March 3rd program featuring Gary Hawk on the history of the Carlos. March 24, the Wondrous Worlds exhibit at the Carlos Museum with Elizabeth Warner. If you want to volunteer for our group, please email Kevin Kell at kevin.david.kell, Kell, @emory.edu. And again, Stephanie, thank you so much for the gift of your time and talent to all of us. We
Thank you
appreciate it.
all so much.
Have a good night, everybody.
Good night.
Bye-bye.